and welcome to Defending the Windy City with experienced attorney David R. Drwencke. David has committed his career to criminal defense and takes pride in working with those accused of crimes, and doing so in a passionate and non-judgmental way. I'm your host, Abigail Vaca, and today is part one of our discussion on checks and balances at risk, police filing charges without prosecutor approval. Thanks for joining me today, David.
Hey, thanks for having me, Abby. Happy to be here.
So, to start, can you explain the new program that allows Chicago police to directly file gun charges without prosecutor approval? And what motivated its creation?
Sure. In many respects, it's a similar program, but it does give a little more latitude to the police, and it really comes down to the very specific facts that the police find on the street or on the ground. And this dovetails to something that was huge here in Illinois about 2 years ago, or even 3 years ago when we were talking about the law, which was the Safety Act or the Pretrial Fairness Act, which the main focus, where most of the time was spent talking about in the news and podcasts and articles and so forth, was just about the elimination of cash bail. But there were a number of other changes in our law, in procedures that changed that didn't get nearly the same attention. And one of them is the ability to cite and release individuals. Now, part of that always existed on misdemeanor charges. An individual, be it the victim, think of perhaps a battery case or a domestic battery, they would be the ones saying, yes, I want to press charges. Yes, I will sign my name to this complaint. And that's enough to bring a charge and get the case to move forward. Police still had some control, even under those circumstances, that they would sign on behalf of a victim or a witness. Now they've got a bit more control on even some felony charges. If they're non-detainable, the officer, him or herself, can be the one who signs off on the charges, signs off on the complaint, will give paperwork, and literally will cite and release that individual with their next court date. And that feels like we're giving all of the power to the police officer. They're the ones who establish whether or not they believe they had probable cause maybe to stop someone. They're the ones who believe they have probable cause that a crime actually was committed. And they're the ones signing off and saying, well, this is when you're going to appear in court for your next date. And that's feels like an awful lot of power for just one person. Fortunately, there are some other mechanisms that we're going to talk about, but that's one of the new things is somebody could perhaps not see a judge at all, be released, have a court date, and the first time they're going to see a state's attorney or a prosecutor or a judge is after all of these other things have been done solely by the police.
Wow, so this move seems to roll back that process that typically serves as a check on police misconduct. What are your thoughts on the potential risks this change poses to due process and accountability?
Well, in the early stages, it is very concerning because there isn't a judge there. There isn't an opportunity for a defense attorney, be it a privately hired one like myself or a public defender, meaning there just no one is speaking up on behalf of a prospective client or a defendant, the accused. That is very concerning. Now, with that negative side, kind of set aside for a second, there are some positives in that the accused may not go before a judge, could be facing a charge, and that's very scary, but they are being released right away without having to wait a night or two in jail, perhaps. They'll be cited, released, they get their paperwork, and then they get in front of a judge, a state's attorney, an opportunity to hire an attorney if that's what they want to do. Again, a private counsel such as myself, but they actually get out faster. That's maybe the silver lining to this, is that eventually a judge, eventually a state's attorney, and eventually some defender, be it a public defender or private counsel, will be involved, but they'll get out sooner. So that's the counterbalance is, well, do you want to wait around longer and we're going to wait for a state's attorney to look at this and wait to go to a judge, and maybe we're going to keep you in custody until we can set a bond? That was the old system where, yes, there were more people involved, but it could go slower. And for some people, they'd rather get their ticket, get their citation. It's like, I'll figure this out later. No, I'm not happy I'm facing a charge, but I'm even happier that I'm not in custody anymore. So that's the trade-offs. No, you're not in custody. Yes, the process can be a little bit faster on the front end, but it also involves fewer eyeballs on this, meaning potentially cases that have less merit move forward when maybe they would have gotten nipped in the bud early within 24 or 48 hours and no charges would have been brought at all. There's pros and cons and kind of good and bad on both sides of this.
Got it. So, in your experience, how might this policy affect the relationship between law enforcement and the communities that they serve?
Absolutely. I think that is the single biggest issue, is that now that officers have so much power and so much control in whether to proceed with a charge or not, they are the ones who, like we talked about earlier, they're the ones who do the initial investigation. They're the ones who do the arrest. They're the ones perhaps signing off on what charges they think they should be moving forward with. It's like, well, why are you playing all of these roles? Where's the oversight? It shouldn't there, we'll refer to them as white shirts here in Illinois, and this is probably true in other jurisdictions, but it's the sergeants, the lieutenants higher up. It's like, well, why aren't they at least looking at this? Shouldn't they be the ones who sign off? It's like, well, the answer is not necessarily that they look at this at all. It could be the officer on the street who does the initial stop, the initial arrest, and then the initial charging, and that can put those officers in a really bad light because listen, you're on a beat, you patrol these streets or this district or this neighborhood, and maybe you start to earn a reputation as somebody who constantly is writing up charges. And yeah, maybe they get dismissed later, great, or they get worked out later, great. But what about in the interim? I've got a loved one or a family member or a friend. It's like they keep getting harassed. They're being brought in and have to go to court and hire an attorney. And now they're worried about having a criminal record. It's like, yeah, there's a lot of moving parts on that. And it puts a lot of power, a lot of stress on those officers, where under an older system, they say, listen, I'm going to do the arrest. I'm doing what I've been trained to do on the streets. This is what I see. But somebody else ultimately approved these charges, be it again, in Illinois, we call it a felony review attorney. It's somebody actually from the state's attorney who will look at the investigation, look at the available evidence as presented at that time. And they can do a thumbs up or a thumbs down, say yay or nay. Do I agree with this? Is there enough? Or no, keep digging, or yeah, there's probably something here, but I'm not satisfied that we're going to be successful at trial. So kick it. Well, that's not happening, at least in very certain types of cases, certain types of charges. We're not having that oversight. And yeah, that can really put an officer who is on the street in conflict with the individuals he's sworn to protect and serve, the people he sees or she sees each and every day on their beat. It's a tough position to be in.
So, you just unpacked a lot. This brings to mind two questions for me. So, what are some of the potential legal implications of allowing police to file charges directly without that oversight from a prosecutor? And could this in turn lead to more unjust or biased charges?
In both cases, we may see a little bit of both. Is that there's too much power with the police that's going to put them in, again, in conflict with their direct neighborhoods, the people that they're policing, the people they're, again, sworn to protect and serve. And then depending on their own subjective biases and things that maybe they're aware of, and some of which maybe they're not, that, yeah, you can have certain officers more apt to okay a charge than other charges would, or other attorneys would be, or the police officers would be, excuse me. But the attorney part is also true, that some states' attorneys would approve these and some wouldn't. There's a great deal of discretion in our system on all levels, from officers on the street, their discretion on whether or not to give a ticket or not, to give a citation or not, and then to what, because maybe there's a more serious version of this, or there could be a less serious version. But then it's true at the state's attorney's level. Which charges are they going to move forward with, and which ones will they say no to? Different states' attorneys have different interpretations. And then even with the judiciary, there is still a great deal of discretion that's afforded judges in how they rule on motions, their interpretation of statutes and case law, whether or not they're going to release somebody with pretrial detention and with what conditions. I run into it every day. I've got yet another example from today where a client is being detained, yet there are plenty of other clients, my clients, that have identical set of facts or nearly identical set of facts, but they're out. It's like, well, why is that? Why do we have inconsistent outcomes on these? It's because there's discretion. A different judge, a different attorney, a different police officer can see the same facts, or effectively the same facts, and reach a different conclusion. And because we're human beings with biases, with levels of prejudice, and I don't even use that word in a negative light necessarily. It's just there are things that we have a bigger problem with than others, things that rub us in a worse way than others, different types of crimes, different fact patterns. And because there's discretion, because we're all coming to this with our own backgrounds and experiences, you can get desperate or different outcomes. And that really does bother people, especially when you're on the wrong end of that. You're not the beneficiary of that discretion, you're the one being punished because of that discretion. That's a tough pill to swallow. And yes, that can feel unjust. That can feel like the system's out to get a specific person or a specific subset of people. That is difficult to digest. The trick is then it's like, well, what do we do to fix this? Do we give less discretion away to officers, to state's attorneys, and to the judge? And now there isn't that leeway to work people out of a jam, out of a tough situation, because guess what? The rules are the rules. This is what it says by statute. I have no option to get you out or to give you a lesser included or to do something positive for a client. So this discretion is a double-edged sword. It can be beneficial to some clients in some situations, and it can be the reason why they're facing a charge altogether in others. It is tough. It's blending that balancing act of the two that we're really, as globally as a proposition, our system is struggling with, and that we're trying to correct and get better at every day.
Certainly, and your example is interesting because this change has been framed as a way to reduce crime and streamline the justice system. So, how do you balance the need for efficiency with the protection of civil rights and preventing abuses of power?
That's really why people hire me, is to protect those civil rights, their constitutional rights. Now, through the prism of a criminal case, I don't bring actual outright civil rights lawsuits against, be it the police or the state or anything like that. I don't do any civil litigation, but it's a protecting someone's civil rights, their constitutional rights, unauthorized and illegal searches and seizures, to not give testimony against yourself, the Fifth Amendment. These are categorical, foundational, bedrock things that I protect each and every day to make sure that people are being treated justly and fairly through the system. And that, you've hit the nail on the head. It's balancing both that, well, we don't want the accused to spend 2 or 3 or more days in custody when we know they're going to be released, which was the old system for a lot of cases. It would take 2 or 3 days. And then the bureaucracy of getting in front of a judge and having the judge grant a minimal bond, or maybe it was a personal recognizance bond where they didn't actually give any money at all. They were going to be released after some paperwork and some processing within a matter of hours. And I'd have clients then look at me and go, well, why was I in custody for 4 days? The judge just let me go. I didn't even have to give any money. I don't get this. And for those people, the new system would be great. They're going to be, here's your paperwork, you're off to the races, you're out. You don't even spend a night in jail, maybe a few hours at the police station. Now, for other folks, other people that may be facing those more serious charges, and granted, those will eventually get in front of a judge sooner rather than later, their concern is, well, wait a second, this is all nonsense. I shouldn't be charged with anything. Why does the officer who's claiming he had probable cause to search me in my car also the one who gets to sign off on charges? Like, this does not feel fair. It's like, well, you're right. We're going to have to live to fight another day. Like, we're going to unpack this. We're going to get to the bottom of it, but it's going to involve getting in front of a judge, having the state's attorney there, starting to go through what's called the discovery process, where we get to see evidence and so forth, see what the state has. But that takes not days, not weeks. And sometimes I can even say it's not even just months. It can abut a year or more on certain types of cases to get all of the discovery, to figure out, state, what do you have? How are you going to support the contention, the allegation that you're making against my client? And all the while, the client has this hanging over their head. They've had to hire an attorney. Maybe this has jeopardized their job, or outright could jeopardize their freedom if they've been detained or they're released. Good, you're not in custody, but now you're wearing an ankle monitor. That's embarrassing for just about everybody, but it could be the reason why you can't keep your employment. It's like there are real consequences just to have an allegation made against you. Even if you win later, a year later, you're found not guilty. The case gets dismissed on a motion or a technicality. Again, great, the right outcome. We reached the right outcome. But what happened in those months between allegation and the right outcome? I've lost my job. I spent time in jail. I wore a monitor. All these different consequences, and you may never be compensated for any of that, unfortunately. Again, you're happy you've been exonerated or we've worked out a great agreement, but you've suffered real consequences between the day of arrest and the day of that resolution.
So, then on a larger scale, what role does oversight and accountability from a prosecutor play in ensuring that charges filed by police are justified and fair? And could removing this step undermine that process?
Well, I believe there's still a great deal of oversight. It's just a matter of when we get there is the problem. Are we talking about days, weeks, months, depending on what part of the process? Eventually, all felonies are certainly going to have some oversight. We are going to get in front of a judge. A state's attorney is going to be assigned to the case, and I will have an opportunity, or the public defender, again, if you were to go that route. Somebody will also represent the accused interests. That eventually does happen, either at a preliminary exam, which is in front of a judge, and that's live, and the officer has to come in and testify as to, again, the probable cause for the search and the arrest and whether or not a crime was even committed. There are some checks and balances there, but it just takes time to get there. Preliminary exam, usually within 30 to 60 days. Why I can say 30 to 60 is that's by statute. If somebody's actually in custody, it has to be within 30 days. If they've been detained, they stay in custody 30 days. If they've been released, well, then it's to take place within 60 days or 2 months, which still that's a significant amount of time that a judge should see this at a preliminary hearing. Now, the state still has a different mechanism, either by choice because they just don't want to do a preliminary hearing, or because their hand gets forced a little bit. What I mean by that is they abut that 30-day or 60-day window. Their officer doesn't appear, whatever, there's some sort of scheduling issue, whatever it may be. They can't proceed within those 30 or 60 days. Well, the case gets dismissed. Awesome. They weren't able to establish probable cause at a preliminary hearing. Great. The case is dismissed. What I caution clients about, and what I would caution anyone listening to the podcast, is that while that is great, you're feeling awesome, you want to go and do skip and cartwheel out the courtroom, that is not necessarily the end of this process, because the state still has the option to go to a grand jury for felony charges. And the grand jury can come back days, weeks, months later themselves. And then you, the accused, will get a letter in the mail saying, you've been indicted by the grand jury. We need to see you in court on such and such a time. And that is obviously heart sinking, nerve wracking, sleep depriving type of news to get in the mail when you thought the case was dismissed. But it is just another mechanism, and it's a check and balance. Again, the grand jury is establishing whether the state has probable cause or not. The old adage as a criminal defense attorney, and any attorneys who might be listening to this are already knowing where I'm going to go and smiling. It's that the old adage is that you can find probable cause on a ham sandwich. It is that it is so easy. It is such a low threshold that and I'll tell clients, if I've participated in 1,000 of these, 999 times out of that 1,000, there's been a finding of probable cause, because it is such a low threshold. It doesn't matter that we have a great defense. It doesn't matter that really that there may be a Fourth Amendment claim or a Fifth Amendment claim. That's for us to solve at the trial court level. Those are to be argued out and are fact questions for a judge or a jury at another day, at another part of the process. So again, there are checks and balances. It's just a matter of how quickly we get there. And right now it feels like the system for certain types of charges has chosen to be faster rather than rely on those checks and balances to have more sets of eyes on things. And I think in Cook County specifically, which is where I'm based, Chicagoland, there's maybe an argument for that, is that there's such volume of cases. There are so many allegations on any given day, any given weekend, that if we wanted to lean further into the checks and balances on the very early end, we'd have more people spending more time in jail. And then, yes, they may get out. Yes, their case may have ended sooner, but they've already lost their job. They've already spent days and days in jail. and they don't want that. Most of my clients just want to be out of there. They want to get out of the police station. They want to get out of court. They don't want to be in custody. So many of my clients, while they may be frustrated that they have to fight the case out, they're oftentimes grateful that they're not in custody or they didn't have to wait days and days and days to get the right answer. It's a balancing act. It really is. And I don't know what the right answer is other than for most clients, they're happy to not be in jail on the front end and happy to fight their case out, even if they're frustrated that the officer should have never brought the charge to begin with. Because as long as they're out, they live to fight another day. They can get their attorney, protect their rights in the long term. And that war is perhaps more important than the battle on the front end for a lot of clients.
Yeah, and I'd love to spend the last minute or two just talking about, from a legal perspective, what types of checks and balances should be in place if police are given more autonomy to file those charges directly, and how could the safeguards be implemented effectively?
Sure, I've got a lot of thoughts on that, and I'll come up some of this is just budgeting, and does the state's attorney, does the county have the money to implement the things that I would suggest? And that's having more state's attorneys assigned to the different districts. It's like, listen, 24 hours a day, 7 days a week, 365 days out of the year, there are state's attorneys who are assigned to that precinct, that district, that can look at cases as they come in, because even the lowest level things still involve some level of booking, still processing, coming through to get fingerprinted and photographed and so forth. It's like, well, let's have some state's attorneys there all the time to at least give a quick glance over this. And it's like, listen, look at this set of facts through the prism or through the glasses of you being an attorney. Sign off on this. We don't need a deep analysis, but just another set of eyes, somebody who's not directly associated with the police department, but somebody who's an attorney who can look at these facts and immediately say, man, there are some serious Fourth and Fifth Amendment problems here, or there are just evidentiary problems. Like, I'm not going to sign off on this because there's no way we're going to be successful at trial. And we can really eliminate some of the low hanging fruit that way. Beyond that would be it's having more judges. In Cook County, to their credit, we do 365 days out of the year. Individuals can be brought before a judge for a detention hearing or a first appearance court. That's great. Now, it still involves being arrested at the right time so you don't spend a day or two in jail. But in other jurisdictions that don't have first appearance court 365 days out of the year, if you have the misfortune of being arrested on a Friday night or over the weekend, you're going to wait Saturday and Sunday and then get to court on a Monday. And that's unfortunate that, an officer with no other oversight, before a judge gets involved, before a state's attorney gets involved, somebody's losing a couple days of their freedom. And what is that worth to different people? That could be their job, that could be their relationship with their family. I mean, it's embarrassing. It could cost you real consequences. So my advice would be to get that oversight, but be able to do so in an efficient manner, that yes, people are being turned around, they are being cited and released, but at least some other set of eyes was glanced over this. Somebody, again, who's not an officer, who doesn't work for the Chicago Police Department or the Cook County Sheriff's Department. It was an attorney who signed off on this and said, yeah, I read this. This is okay on the early stages. It's enough for right now. And then eventually a judge and for a preliminary exam or a grand jury will get to look at this and we go further on into the process. But it'd be nice to have at least one other set of eyes very early.
Wow, this has been great information. Thank you so much for joining me today.
Thank you. I really appreciate it.
Thank you for joining us for Defending the Windy City. You can find David at www.drdlawllc.com. Please like, subscribe, and leave a review on your favorite platform.